Assalamualaikum and good day to our lecturer and fellow friends. Today, we are from Group 7 who would like to present about Contracts Act 1950, Act 136, about Contingent Contract and Contract of Indemnity. Before we continue our presentation, let me introduce our group members. My name is Muhammad AMREE bin ZAHARUDDIN as the first presenter, and the second presenter is Muhammad HEIZAL Fahmi bin Muhammad Jaiz, and the last presenter is JONG Hui. Okay, now let's take a look at our content for this presentation today. We have three parts which consist of contingent contract, and the second part is contract of indemnity, and the last part is the conclusion. For the contingent contract, we will have the introduction, enforcement of contingent contract, contract to be deemed impossible, contracts become void, contracts may be enforced, agreement contingent on impossible events void, advantages, case study, and for the second part, we will have introduction, right of indemnity holder when sued, advantage and disadvantage, and case study. Okay, next. Okay, for part 1, which is contingent contract, I will present about the part 4 of contingent contract. Okay, for the introduction, section 32 under Contract Act 1950, Act 136 state that a contingent contract is a contract to do or not to do something if some event collateral to the contract does or does not happen. This is the illustration. A contracts to pay B 10,000 ringgit if B's house is burned. This is a contingent contract. Okay, for the enforcement of contracts contingent, it is divided by two, which is an event happening and an event not happening. Okay, section 33, enforcement of contracts contingent on an event happening, state that contingent contracts to do or not to do anything if an uncertain future event happens cannot be enforced by law unless and until that event has happened. Second part is if the event become impossible, such contract may become void. For the illustration at section 33, A makes a contract with B to buy B's horse if A survives C. This contract cannot be enforced by law unless and until C dies in A's lifetime. Second one is A contracts to pay B a sum of money when B marries C. C dies without being married to B. The contract becomes void. Okay, for the section 34, which is enforcement of contracts contingent on an event not happening. This section states that contingent contracts to do or not to do anything if an uncertain future event does not happen can be enforced when the happening of that event becomes impossible and not happening. Okay, for the illustration at section 34, A agrees to pay B a sum of money if a certain ship does not return. The ship is sunk. The contract can be enforced when the ship sinks. Okay, for this part, I will pass to my friend Muhammad HEIZAL Fahmi to continue our group presentation. Thank you.
Assalamualaikum. Hi, I'm Muhammad HEIZAL Fahmi. So I will continue explain contract to be deemed impossible in contingent contract. Section 35, when event on which contract is contingent to be deemed impossible if it is the future conduct of a living person. So it said if the future event on which a contract is contingent is the way in which a person will act at an specified time, the event shall be considered to become impossible when such person does anything which renders it impossible that he should so act within any definite time, or otherwise that under further contingencies. So the illustration for section 35, when event on which contract is contingent to be deemed impossible if it is the future conduct of a living person. It says A agrees to pay B a sum of money if B marries C. C marries B. The marriage of B to C must now be considered impossible, although it is possible that B may die and that C may afterwards marry B. The contract become void in section 36 in bracket 1 when contracts become void which are contingent on happening of specified event within fixed time. The contingent contracts to do or not to do anything if a specified uncertain event happens within a fixed time become void if at the expiration of the time fixed the event has not happened, or if become the time fixed the event becomes impossible. Next. So in section 36 in bracket 2, When contracts may be enforced which are contingent on specified event not happening within fixed time, the contingent contract to do or not to do anything if a specified uncertain event does not happen within a fixed time may be enforced by law when the time fixed has expired and the event has not happened or before the time fixed has expired if it becomes certain that the event will not happen. Next. So illustration in section 36, 4.1, A promised to pay B a sum of money if a certain ship returns within a year. The contract may be enforced if the ship returns within the year and becomes void if the ship is burned within the year. The second point is A promised to pay B a sum of money if a certain ship does not return within a year. The contract may be enforced if the ship does not return within the year or is burned within the year. So the next one is agreement contingent on impossible events void in section 37. Agreement contingent on impossible events void. So the contingent agreements to do or not to do anything if a possible event happens are void. Whether the impossibility of the event is known or not to the parties to the agreement at the time when it is made. So the illustration for section 37, agreement contingent on impossible events void. Is that for point 1, A agrees to pay B 1,000 ringgit if two straight lines shoot across a space. The agreement is void. The second one is A agrees to pay B 1,000 ringgit if B will marry A's daughter C. C was dead at the time of the agreement. The agreement is void. So the advantages for contingent contract, one is allowing both parties to bet on what they predict will happen instead of having to come to an agreement immediately away. The second one is the parameters of what will happen in reaction to a specific event are explicitly specified in the agreement. This limits the need for future litigation. So the last one is allow commitments to become self-enforcing by eliminating the need to renegotiate or make adjustments when situations occur. So this is some of the case study for contingent contracts you can see here. So the next slide will present by my friend Jong Lin Hui. So thanks very much for me.
Hi everyone, I'm Jong Lin Hui. I'll present for the part of the indemnity of contract of indemnity. Okay, this is the Contract Act 1950 under Act 136 is the part 8 of the indemnity and guarantee. Section 77, a contract by which one party promised to save the other from loss caused to him by the conduct of the promisor himself or by the conduct of any other person is called a contract of indemnity. Illustration for the section 77. A contracts to indemnity B against the consequence of any proceeding with which C may take against B in respect of a certain sum of 200 ringgit Malaysia. This is a contract of indemnity. Section 78 is the right of indemnity holder when sued. When the promisee in the contract of indemnity acting within the scope of his authority is entitled to recover from the promisor under a few conditions, which is A, under condition A, all damage which he may be compelled to pay in any suit in respect of any matter to which the promise to indemnity applies. Condition B is all costs which he may compel to pay in any such suit if in bringing or defending it he did not contravene the orders of the promisor and acted as it would have been prudent for him to act in the absence of any contracts of indemnity, or if the promisor authorized him to bring or defend the suit. And condition C is all sum which he may have paid under the terms of any compromise of any such suit if the compromise was not contrary to the orders of the promisor and was one which it would have been prudent for the promisee to make in the absence of any contracts of indemnity, or if the promisor authorized him to compromise the suit. Okay, here is the some advantages and disadvantage of the contract of indemnity. The advantages is remoteness of the damage. It can be structured to cover any types of expected loss. Second one is the mitigation of loss. A party to a contract has an obligation to mitigate loss resulting from a branch of contract. However, this does not apply to a claim under an indemnity. Third advantage is the statutory limitation period. If an indemnity is properly structured, the contract will only start execute if the party providing the indemnity fails to respond to a claim made under it, effectively extending the standard statutory limitation time. The disadvantage of this contract of indemnity is it can be a complex process determining whether or not a loss is covered. Here is some case study in the Federal Court of Malaysia at Putrajaya. Then the second one, also the case study about the indemnity of insurance and the license and guarantee. Okay. This is some of the example of the latter, whether it's the public sector or private sector. This is the letter of indemnity for the between the nominated subcontractor to the government. They will be signed this letter and returned to government in their contract. The second one is the letter of indemnity under private sector. Is the also same with the public sector, also the subcontractor to contractor. Contractor here means is the main contractor. Also the agreements that will state the detail of the indemnity. Okay, come to the conclusion. In a nutshell, a contingent contract is one that is utilized in everyday lives and describe contract in which a commitment is conditional on the occurrence or non-occurrence of some uncertain future events. As a result, it aids in the completion of acts that are required in insurance, guarantee, and negotiation. This sort of contract, however, cannot be utilized in standard contract. Next, contractual indemnities are a great way to shift risk from one contracting party to another in the case of a certain incident. They allow them to extend the period for filing a claim in order to avoid concerns with caution, distance, and mitigation. The courts, on the other hand, are servants in their applications and will be controlled against the person requesting indemnity. That's all from our Group 7. Thanks for listening to us. Thank you.